when you stop looking at your work as what IPR do I need and start looking at it as how does it need to be protected, that'll give you the answer to what IPR best protects your work. Hello, everyone, and welcome back to the Sum of Everything podcast, where we discuss a little bit of a lot of topics. I'm your host, Aishwarya, and welcome to part 2 of IP for Creatives. Now, if you haven't already watched part 1, I would highly recommend you do so before you watch this episode, because we are going to take off from the concepts discussed in that episode. Remember the protection of expressions and not ideas, and the different categorizations of the different kinds of intellectual property rights? Yeah, that. In this week's episode, I thought we could discuss how you're going to protect the creation that you've made. So let's start from the basics, right? You've made something. It's amazing. You had an amazing idea, and then you went about bringing it to life. It could have been a song. It could be a book. Maybe you wrote a play, whatever. Let's take a book, for example. You thought about a great murder mystery plot, and then you decided this is the best. I want to write a book about it. And you worked on it for 6 months, and then you brought it to life, and it reads amazingly. What are you going to protect it under? Well, for starters, you're going to protect the work itself, what you've written, the story, as a literary work under copyright, because it's a creative expression of your idea. Keyword, creative expression. Similarly, if you were to write a song, that song would be made up of different components, and those components would be the lyrics, the composition, the melody, and the chord progression. All of that put together, that's a song, right? So a song is a complex work. Each element of that song could be copyrighted separately. For instance, the lyrics would be copyrighted under literary works. The melody itself could be a composition, so it would be a musical work. When you record that song, put everything together, that would be a sound recording. That has its own separate protection under copyright. So the Indian Copyright Act classifies the different kinds of works into 6 categories. You have literary works, you have musical works, artistic works, so the paintings, photography, anything that is creative in that way. Drawing, sketches, any of that stuff. That's an artistic work. You have dramatic works. This would be plays, anything that is to be performed. That would be a dramatic work. And then you have sound recordings and cinematograph films. So sound recordings would be the masters of a song that you create. Or even this, if I were to go and record someone's speech, my recording of their speech would be a sound recording, and I would have copyright over that sound recording. But the speech itself, now that could fall under one of 2 categories. It could be a literary work if it is simply written, but if it is performed and there's an element of performance in that, then that would be a dramatic work. And that copyright would vest with the person who wrote the speech or performed the speech, right? Now, I think a question that I get asked a lot is, when do I get copyright? Don't I have to register the copyright? The short answer to that is no, you don't have to register a copyright. And I know that is surprising to hear. Copyright is a natural right, meaning it vests, or you have copyright over your creation as soon as you create it. So if I were to think up a short story and I simply wrote it down, I would have copyright over that short story, over the expression of that idea, as soon as I actually wrote it down. I don't need to go to the copyright registrar and get it registered to show that, hey, I have copyright over it. That's how India as a jurisdiction works. And for that matter, most jurisdictions around the world work like that. So copyright is a natural right. It comes into existence as soon as the work is created. Now, this could literally be scribbles on your sketchbook. So if I was bored and I just decided to doodle, I would have copyright over those doodles. Nobody can use those doodles and print them on anything and sell them. They would be violating my copyright. Now, I think the next normal question to ask would be, then why do we have registration of a copyright, right? Good question. The registration of a copyright only comes in handy when you are actually litigating a copyright and it becomes evidentiary proof that you have copyright over whatever the work is being discussed. What that means is, if I have registered a copyright over something, when I go to court and I say XYZ has infringed my copyright, which is legalese for violated my copyright, I don't have to prove that I have copyright over it. However, if I haven't registered my copyright, what that does is, first I have to say, hey, this is my copyright. I created it first. And this is when I created it. This is what I was thinking. This is the reason I created it, etc., etc., etc. That is what you have to go and prove to the court. I don't have to do that if I have a registration. But in most cases, you're not going to sit and, like, even if you make the most beautiful work of art, right? You're not going to sit and get that copyrighted. It's unnecessary. Unless you're absolutely sure someone's going to infringe it, and then you're like, oh no, I don't want the evidentiary burden on me. I want the defendant to prove that they didn't infringe my copyright. But anyway, that is the legal part of it. Long and short of this is, do you have copyright in something even if you don't register it? Yes. If you have created it, then you have copyright over it. Simple? Okay, awesome. Next, let's change the example a little bit. Suppose you decide to open a coffee shop and you call it, I don't know, the Great Bean Theory. Now, the name, the Great Bean Theory, becomes your trademark because it is the name and the mark with which your trade, your business, the services that you're offering is being identified. If somebody else next door were to open a shop, coffee shop next door, and call it the Bean Great Theory, that would cause a little bit of confusion, right? So the point of a trademark is to ensure that the goods or the services that are being provided are identifiable with the person or entity or company or whatever providing it. Which is why if you were to walk down a random street and you see a salon called Lakme Salon, but it's not written like a Lakme Salon, the way the font is supposed to be. Or you see a salon that's called Lakshmi Salon, but it's written in exactly the same way Lakme is written, that would also be an infringement of trademark, because what you're trying to do is you are trying to create confusion. You are trying to benefit off of the goodwill and the reputation that has been garnered by the Lakme trademark. And you're trying to pass off your services as those of Lakme's. So, two things when you're using a trademark. You have to ensure that it is distinctive enough that it is easily recognizable as your services. Now, it doesn't mean it has to have your name. It's just, it has to be yours and it is distinctive enough. And at the same time, it can't be descriptive of what you're providing. Otherwise, it's never going to work, right? I can't call my podcast the podcast. That's not going to work because it's not distinctive enough. Anybody could call their podcast the podcast. It's similar to trying to copyright an idea. Can't do that. It has to be distinctive. It cannot be descriptive of the business or the services or the goods that you're providing, right? And of course, there are some other rules about how you go about choosing your trademark. That's too much detail to go into. Basic thing to remember is it should be distinctive and it should not be confusingly similar to somebody else's trademark, right? So come back to the coffee shop. We are the Great Bean Theory. Along with the name, the Great Bean, you also design a logo. Now that logo has an artwork. Now that artwork would come under artistic work. And so you can protect that as a copyright as well. And you can also protect that as a trademark. Now, I'll come to why that is important a little bit later. Trademarks Do I register them? Do I not register them? Answer is, in India specifically, you can do both, because India is something called a use first country. Now, what does that mean? Uh, a trademark can be used without registration and still be recognized as being identified with the person providing it, provided that if you wanted to sue somebody for using something very similar, you couldn't claim something called infringement. What you would be able to claim is passing off, because that's a common law right. Now, what does that mean? If I register my trademark, right, I can say, hey, this is my registered trademark and you're infringing it. You're violating my statutory right to use this trademark exclusively. However, if I don't have a registered trademark, but I can prove that the Great Bean Theory is something that I have been using for X number of years continuously in business, and people identify this name with my coffee shop and my coffee shop alone, then I can say that anybody who's using a mark that's very similar to mine or a name very similar to mine is trying to benefit off of my reputation. And that is what is called passing off. You're trying to pass off your goods or services as someone else's. Because if another, say I have this coffee shop in Bangalore and somebody else opens up another coffee shop in Mumbai called the Great Bean Theory, except the shop in Bangalore is very, very famous. It's done superbly, and people just think the Great Bean Theory or GBT. You say Great Bean Theory and you can think of only one particular shop, my coffee shop. If somebody were to open a similar shop in Mumbai, there is a chance that people will confuse that shop, that new coffee shop, as a branch of mine. It's possible. Now, it depends on how far and wide your reputation has spread, right? A real life example would be take Naru noodle bar, right? Eat Naru. Suppose another shop in a different part of the country, Delhi, opened up a store called Eat Naru and did the same thing, basically served Japanese food under the name Eat Naru. The one in Bangalore is famous enough to say that, hey, you are passing off your services under my name as though it is mine. This is assuming Eat Naru is not a registered trademark. So that would be passing off. Registration would help, because when you register, you have the dual right to say that, hey, you're infringing my trademark and you're passing off, because passing off is not a statutory right. It's a common law right. It's basic. It's equivalent to when people have freedom of expression and say, hey, it's my right to move around as much as I want to. And the response to that is, your right ends where my nose begins. It's like that. Now, remember we talked about the fact that you can have both copyright and trademark over the logo. Now, the logo can be a trademark because you are being identified by that logo. But the artistic work, you've made a really cool drawing about it, and that artistic work, that can be copyrighted as well. And where it comes in handy is, for example, suppose somebody decides to print that logo and it's beautiful. Maybe it's like a coffee cup and like coffee beans or whatever. Someone decides to take that and print it as a poster and sell that. Now, that person is not trying to pass off as a coffee shop. They're not trying to say that, hey, I'm affiliated to the coffee shop. No one's going to believe that a cheap poster that's sold on a street side is related to the actual coffee shop. You won't be able to claim trademark infringement over there because they're not doing it as a business. What they are doing, however, is infringing your copyright in the artistic work, because nobody else is allowed to use the artistic work that you have made, right? You only are allowed to make copies of it, distribute it, publish it to the public, whatever. The bundle of rights, that is a copyright. Only you are allowed to do that. So if somebody else is doing it, that is taking your artistic work, printing it on a t-shirt and selling it, that would be a copyright infringement, even though it might not necessarily be a trademark infringement. So there you go. You can have two different categories of IPR subsisting in this with respect to the same work, but protecting different parts of the work. Where the trademark protects the identity, the copyright protects the artwork. Now, imagine you decided that simply having a logo and putting it on merch is not enough. You wanted to create something super unique. So you decided that you wanted to make a coffee mug in the shape of a coffee bean. You decide to draw the sketch that you have in mind, and then you give it to somebody who is able to manufacture it, right? Now, it's the most unique thing you've ever seen because it is not only amazing in the shape that it is, it's also the texture that it is. It's a pattern that has never been seen before, super unique, super new, and it covers everything that needs to be in a design that is registered, which is it is new and unique, never seen before, completely original. It has not been published anywhere because you kept it a secret. Like you made a drawing about it and then you sent it to for it to be manufactured. So super secret. It's never been shown before. And the manufacturer says that this is something that can be made through an industrial process. Like it doesn't have to be made using a pottery wheel, like factories can make it. Then it would qualify as a design that can be registered. So then you go ahead and register that design. So an article, a pattern or something that is new and completely original, not published before, never seen before, and is also able to be applied through an industrial process and is not obscene, basic, like, oh, it can't be against public morality, that kind of stuff. Then you can get it registered as a design. Now, you'd also maybe ask the question that, hey, I drew those sketches. Do I have copyright over that? Yes. Up until the point that you decide that you don't want to register the design and you want to make it a limited edition mug. So you keep less than 50 editions of that mug. Now, if there are more than 50 editions of that, then potentially you will lose the copyright over that mug but it can be protected as a design. So between copyright and designs, you can have some overlap, but there are limitations to that overlap. And the reason for that is you can't enjoy statutory rights that are endless, where you sue someone for design infringement and copyright infringement and trademark infringement, all of that, right? For the same cause of action or for the same action, you can't sue under multiple acts. And that is basically the logic behind this. Okay, so we've covered now copyright, trademarks, designs. Now the all important patents, right? Now this one gets a little bit tricky. So let's think about it this way. Suppose you have invented a coffee machine that can produce the most amazing coffee from start to finish. Like literally, you put in raw beans and in 10 seconds flat, you have a coffee ready, not roasted beans and then like ground and then put into the coffee machine, tamped, and then like espresso generated. No, like a full coffee. Say you want a latte, you can literally put in fresh beans and then in 10 seconds flat, your latte is ready. Now, A, that is a machine, that is an invention. B, it has solved a problem. What problem has it solved, or how has it made life more convenient? The entire process of coffee being roasted to coffee being served is shortened to 10 seconds. So it is novel, it is an inventive step, and it has industrial application. So you can patent it. It's as simple as that. There's really no two ways about it. Once you patent it, you'll have patent protection for 20 years. Now, with patents, what is important is you have to register it. You cannot not register a patent. Patent doesn't come into existence just by virtue of you having invented something new. Patent has to be granted. And for a patent to be granted, you need to provide all information about that invention in writing as claims. What it can do, how it is to be put together, all of it. Every single little detail of that invention is given in the patent application. And this is why, if you remember in my previous episode, I said that you can't patent an idea or even an app necessarily, because if you want to keep it a secret, if your entire worry is someone will steal it, then the patent is not for you. Patent is not what you're going to be protecting your IP under, because the very basis of being granted a patent is disclosure. You have to disclose to be granted that patent. It's as simple as that. And this is something that I was trying to explain to my friend, the same guy with the app, today, earlier, on the phone for about 20 minutes, until I kind of yelled at him and said, "Oh, watch my episode. It's going to be so much easier for you to understand what I'm talking about." Anyway, so that is a patent, and that's how patents are granted. Also, something that I don't think I mentioned before, all of these, the duration of protection is from the date the application is filed or the date the work comes into existence. In case of patents, it would be the date the application is filed. So it would be 20 years from the filing date of the application, not from the date of grant of patent. Now, that is important because a lot of times grant of patent takes years because they have to conduct a prior art search. What is a prior art search? They have to ensure that the invention that you have submitted for a patent, there's nothing like it before. Nothing of the sort exists in the world, because it has to be a new thing. It has to be original. It has to be novel. It has to be new. And that is one of the basic eligibility criteria for an invention to be granted a patent. So yeah, for my techies out there, if you come up with an idea for a brilliant app and you work on it and you make the app, the question is it solving a technology problem, or is it solving a different kind of problem where the technology already exists? You're not creating new technology. You're solving maybe an inconvenience. That is like a food delivery app. That is an app that connects people to people through phone. And instead of calling the restaurant directly, you place it on an app and the app goes and does it, like, all the different food delivery apps that we have. That's not a technology. GPS is a technology. 5G is a technology. Those get patented. An app, not necessarily, not if it's not solving a major issue, a technology related issue. So, yeah, I hope that is clear about patents. Now, we've covered the major 4 kinds of IPRs, but there's one left, right? Trade secrets, right? This is easily the simplest one to understand. Now, in that machine of the cool machine that you've invented, you also have come up with a recipe for the most delectable, foamy, creamy latte. And how you make that latte is a complete secret. Like, you have decided that you want to keep that a complete secret, because if everybody knew, then everybody would end up selling that in their coffee shops and your USP would be completely destroyed. So how you make that latte and what you add into that latte, who knows? How do you make it creamy? God knows, you know. But that is a trade secret. And the only people who come to know that is maybe the special barista who's given access to your recipe, where you have instructed them on how to make it perfectly. That one person, trusted person, who is under contractual obligation to not reveal it to anybody else, even if they quit your employment. And that is the definition of a trade secret. If you are employed or have ever been employed by a company, you will find that your employment contract generally contains a non-disclosure clause or a confidentiality clause, where they're talking about you not ever revealing the different things, like whatever you're working. Maybe if you're a techie, like a lot of people in Bangalore are, then the software that you worked on for the company, or the projects that you worked on for the company, or the special source code that you had access to as a part of the company, which is the company's trade secret. You can't go and reveal that when you move to your next company. Then you would be violating the non-disclosure agreement that you have, and you are likely to be sued. It's as simple as that. So that is a trade secret. So we've covered what you can protect expression, not the idea. And we've covered how to protect your creations. If you see any creation that you make, it can be protected in multiple different ways. It depends on how you look at what you have created and what the purpose of the protection is. When you stop looking at your work as what IPR do I need and start looking at it as how does it need to be protected, that'll give you the answer to what IPR best protects your work. That has been our episode today. I hope the basics of intellectual property rights are clear to you. If you know anybody who might benefit from this episode or has something to protect, please do share this episode with them. I am planning on continuing this series and providing little tidbits of information about IPRs and the different ways IPRs can be used to your advantage. So if you have any questions or if you have any topics that you would like me to cover, please let me know in the comments and I will try my best to answer all of your questions. But that's it for this episode, and I hope to see you in the next one. Bye-bye.